You definitely don't want to miss this one today. Today, we're going to be breaking down a whole slew of not only legal cases, but also the scenarios that are playing out right here within the crypto sphere and also within the investor community. There's going to be a lot happening, I think, over the next few months and next few years as we start to see a lot of things form through a lot of these decisions that are taking place. So we'll break it down for you today. It's going to be a good one. My name is Paul Barron. Welcome back into Tech Path. Joining me today, of course, is Mr. James Murphy coming in from MetaLaw. Great to see you.
Hey, Paul. It's always great to be on with you. So much going on in the crypto legal sphere.
No doubt. I mean, the amount of activity that's been happening, obviously within the courts, but also just on the sidelines from a political standpoint. James, I want to jump into the Uniswap case first. And I'm going to go over to a couple of pieces here. We'll go to page 28. There's one notice right here on that filing right there. It says, concerns are better addressed to Congress than to this court. It feels like a lot of these judges are getting a little testy with this. And what is your opinion? I mean, obviously, as an attorney who's been in these kind of cases before, is there something that the judge is saying here, don't bring this to my court again, or what's going on?
Yeah, absolutely. I'll tell you, first of all, that Uniswap decision is really a tour de force in terms of a judge understanding the technology of DeFi. Really shocking, because you've really got to dig in, go down the rabbit hole, and really understand how liquidity pools work, et cetera, et cetera. She obviously did that and concluded, wow, this is an asset class and a trading platform ecosystem that is unlike anything we have seen. And really, it cries out for action by Congress to establish some rules and parameters. And that's what she's saying there. And it really is a signal, I think. She's handling the Coinbase case, the SEC versus Coinbase as well. And I think it's a little bit of a signal that she would be receptive to Coinbase's argument about the major questions doctrine.
Yeah, I think that is we'll get a chance to talk about that here in a second. I'm going to show you a clip from Paul Grayscale. But going back to the Uniswap document, there was on page 35, if you guys are following along and you've downloaded these documents, on page 35, there's a statement in there that says the court finds that the smart contracts were themselves able to be carried out lawfully, as with the exchange of crypto commodities, Ethereum and Bitcoin. Another big statement here from the judge, especially in the camp of Ethereum becoming a true, or at least in the eyes of the court, a true commodity. How much will this affect, or will it affect the SEC looking at Ethereum in the future?
It's a good question. It's not a binding finding in the sense that I don't think they litigated what the status of Ethereum was, because in that case, what they were talking about are what are described as scam tokens. So she just said that because I think she's believes that that's sort of the accepted understanding, and it's certainly the position of the CFTC that Ethereum is a commodity. And so she endorsed that point of view, but it was not litigated, so it's not binding on the SEC. But of course, she's probably correct about that, and it aligns with what the CFTC has said. But the SEC, we found, has a mind of its own and will pursue its own agenda.
Yeah, for sure. I want to play a clip for you because, as you mentioned, Judge Failla also presiding over the Coinbase case. A lot of scenarios may play out in this. Here's a clip from Paul Grayscale. Listen in.
We're actually pushing hard for an early resolution by the court as a matter of law, and as quickly as the court is able to do it. And we were quite pleased to see that the district judge presiding over our case agreed that these issues could be presented on early motions. And the SEC will soon file its response. We'll have a chance to reply. And after that, we may or may not have oral argument depending on what the judge wants. All of that tells me that no decision is going to come certainly before October. We hope that a decision will come before the end of the year, but that's ultimately in the trial judge's hands.
Do you think October is a good date for this, based on some of the timing of this court case?
So the briefing on this the SEC's response is due on October 3rd. I'll tell you what's interesting, Paul, is 7 days after that, we will see whether there are any amicus that want to enter and support the SEC's position, which I'm really looking forward to seeing if anyone's going to do that and argue that all of these the trading on Coinbase is trading in investment contracts. I think that's clearly wrong. But we shall see. And then Coinbase gets to respond and have the final word, I think October 24th. And I'm a little bit in the Paul Grewal camp that we could have a decision before the end of this year. And the reason I say that is the judge did a lot of work in that Uniswap case. And she specifically cited that the Congress has not yet determined whether digital assets are commodities, securities, or something else. And so that is a very strong signal that I think she's going to be very receptive to Coinbase's arguments. I like their chances, and I like the chances of a decision before the end of the year.
We've got the ETH futures also launching in October. Do you think that helps the Coinbase case at all?
I'll tell you what helps Coinbase is that the CFTC, through the SRO, gave them a future commission merchant license. And so they've demonstrated that if there is a clear rule book on what you need to do in order to be licensed, they will follow it. And I think it was a 2-year process to convince the CFTC and the self-regulatory organization that they had satisfied the rules. And that's what they've been asking for years, is a clear rule book from the SEC on how you can be licensed to trade digital assets in the spot market. And the SEC has just refused to entertain that idea. And it just goes to show you that Gensler's repeated statement that these people in general don't want to follow the law, they want to be law violators, is just not true.
Yeah. Why? Okay, I know this is a bigger question, but you look at the political landscape currently, what's happening with regulatory scenarios playing into all of this. Why is Gensler and the SEC so staunch on this direction now that they're starting to see these losses pile up? Do you have any theory on that?
Well, the theory is it's political, and that he's being strongly encouraged to pursue this course. And I think that's very possible, maybe even likely, because I got to tell you, Paul, it is embarrassing for him to testify in Congress in May of 2021 that there is no regulatory regime for exchanges like Coinbase, and then with no action whatsoever from Congress to just do a 180-degree turn and say, well, it turns out that we have all the authority we need to regulate exchanges. That's embarrassing. He has no law to support that argument. So I think he was encouraged by forces that I don't know who they are.
I think a lot of people have ideas. Let's jump over to the Ripple case a little bit. I want to show a tweet here from Stuart Alderati, obviously the Ripple attorney. Ripple just filed its opposition to the SEC request for interlocutory interim appeal. Worth a read, especially the footnotes. He's getting into one of my personal favorites. So some interesting things kind of jesting with what's happening. Do you think the SEC is going to get thrown out in terms of an appeal?
I believe the judge is going to deny the request to certify an interlocutory appeal. Again, Ripple did a masterful job of taking apart the SEC's argument. Just so people understand, interlocutory appeal is very unusual and really unusual in a summary judgment scenario. What you need is a very clean legal argument that says if the court rules in our favor, this case is over. The best example is some kind of immunity. So if the defendant is immune because it's a state actor, a law enforcement, for instance, or people have heard of diplomatic immunity, the case goes away if the immunity is upheld. That is the best example. Here we have an extreme amount of factual issues that the judge had to sort through in determining that there were not sales of securities, investment contracts in open market sales, for instance. And so that's not a good fit for an interlocutory appeal. So I think it is unlikely that the judge would grant an interlocutory appeal in these circumstances, which means they're on to trial, in the second quarter of next year. Although, fascinating, the SEC is hinting they really don't want to try that case against Garlinghouse and Larson, who have very strong defenses in that case. So we shall see, but I would expect a pretty quick denial of the motion to certify interlocutory appeal.
So the denial comes in, SEC says, maybe I'm not necessarily ready to go, or they're not ready to go to trial. Do they just drop the case at that point, or what happens to that case?
Well, this is just one count, against the individuals. And so what they would do is go on to the penalty phase for the count that they won, which is the institutional sales directly from XRP to VCs and other institutional players that were governed by a contract with certain provisions that made it look like a security to Judge Torres. And then they got to figure out, well, what is the penalty? So that's pretty complicated, and that could take a while.
I'm going to jump over to Grayscale versus the SEC. This was a tweet by Gensler. Our SEC Investor Ed team updated their investor bulletin on leveraged and or inverse exchange traded funds, ETFs. What are ETFs? The leverage inverse ETFs. Why do leverage inverse ETFs have extra risk for buy and hold investors? And then they kind of go in and do this. When you look at what happened within the case with Grayscale, what is the SEC's position now that they've pretty much been dismantled here on this particular issue?
Well, they're confronted with a very difficult decision. And by the way, this is the second time in about a month or so that court, the D.C. Circuit Court of Appeals, has found that the SEC acted in an arbitrary and capricious manner. And that's a stinger. That is quite a rebuke. And so there are a whole host of options, of permutations to those options. One option would be to simply permit Grayscale to convert that existing trust into an ETF. There's an option to appeal. They could seek a rehearing at the same court, or they could try to appeal petition for a writ of certiorari to the U.S. Supreme Court. I think they will lose in both of those instances. And the other option is to rescind the approval of the derivative ETFs. I believe that is the least likely scenario. A lot of people are talking about that. I think it is unlikely because they published a full explanation going through all of the factors that they considered in approving those ETFs. So reversing course would instantly result in lawsuits by those two sponsors of those two ETFs, and they would have a very good case that the reversal of a well-reasoned decision is itself arbitrary and capricious.
Right.
So it's really hard to say. This is a very political decision now. I think Gensler doesn't want to be seen to endorse the ETF, and so he may try to delay action, which would be some sort of appeal, which has very little chance of success.
Yeah, he seems like he's definitely being backed into a corner, which you always are cautious as when you get someone in that kind of scenario, especially from a political landscape like what appears to be showcasing through the SEC. When you look at the investor community with GBDC, I was going over to the charts here just to show you all the way back, the low back here in January of 23, where they had literally a 48% discount on Bitcoin in the trust. Now it's starting to recover here, but does this prove that the SEC has actually been hurting investors with the fact that the court has come out and said, hey, you're completely wrong here on all of this, and you've been suppressing the opportunity here for Grayscale to actually convert to an ETF?
Yes, I think it does. And this isn't the only instance of that happening, that the SEC is hurting investors. The Ripple case is another great example of that. But yeah, here you've got it actually measured, Paul. I like that chart. showing the amount, of the damage that was done by the SEC, placing this cloud over the possibility of conversion to an ETF where that whole discount presumably would go to zero. Yeah, I agree with your take. This is another instance of the SEC acting contrary to the interests of the investing public.
Has there ever been a scenario where investors collectively have tried to launch a lawsuit against the SEC outside of someone like a Mark Cuban, who obviously, was able to, that was more of a reaction to what the SEC was doing, but more on a proactive level?
I'm unaware of any successful effort to do that. They have an array of defenses. It is the position of our government to protect government officials from liability and agencies in particular. So, successful actions of that kind are very few and far between against any kind of government entity, unless you can really prove a level of corruption instead of just sort of bad judgment, maybe even a little unethical. You really need corruption to have a good chance in court against a government agency.
I had Eric Balchunas on from Bloomberg this week, and we had a chance to kind of go into Gensler's future. A lot of this is, as you have indicated, really surrounds the political landscape and some of the things that are happening right now, typically and normally happen in a lot of these kinds of tit for tat type situations. But now we're moving into an election year. So things are really going to start getting heated up. Is there a point when Gensler just becomes too much political baggage for the Democrats and they do something? I mean, I'm looking at, he's still got 1,000 days in office right now. And that's if a Republican or the GOP do take the White House and potentially maybe the Congress as well. What are your thoughts on how this plays out for the Democrats with Gensler at the kind of their flagship person, fighting against crypto here?
Well, it's a good question. A lot of debate about that. On Twitter, a lot of people believe, wow, it's inevitable that he'll be fired because he's this liability. I think we need to be careful. In my business, in litigation, talk about being careful. Don't drink your own whiskey. So we're knowledgeable about crypto, but most of the world, most of the political people are really not. And I think Gensler is receiving encouragement from a number of, liberal, progressive people who like what he's doing in attacking crypto. And the president, I think, may be among those who believe that what he's doing is exactly what the president and the White House have in mind. Remember, this Operation Choke Point 2.0 is not an SEC initiative. It's a whole of government initiative. The banking regulators, Treasury, Fed, SEC, all of them, and law enforcement, criminal law enforcement agencies. So this is a comprehensive effort by this administration. And so he may be hearing that he's doing exactly what those people in power want him to do. And they probably have polling that suggests that the pro-crypto contingent is small and will not affect the outcome. And best evidence of that is Elizabeth Warren, when announcing her reelection bid, made a point of saying she is putting together an anti-crypto army. And she would not have said that unless she had some polling data that said this is a good thing. For attracting votes. So, no, I would be surprised if he's fired anytime soon.
Interesting. Even with all the losses that have been piling up, I mean, granted, he's had a handful of semi-wins, but some of these are fairly public and in some cases have huge implications. Doesn't the political landscape, especially the lawmakers out there, look at this and go, how many more of these are we going to take on the chin?
Yeah, no, you make a valid point. These kinds of losses, saying this agency is acting in an arbitrary and capricious manner, that this agency does not have, allegiance to the law and is changing positions without explanation, is harmful to the institution for sure. And this is unusual. I mean, the SEC has taken losses historically, occasionally, but kind of this is really a lot to be taking on. And so, but again, how many people are really paying attention? We're a little bit in an echo chamber where we're talking to each other, and this is meaningful to us. But your point is well taken. It's unusual, the number of losses and the manner in which judges have been reacting to the positions taken by the SEC is I think it's darn near unprecedented, Paul, certainly in my career.
Yeah, it's very interesting to watch this for sure. And I think, again, one of the ways that you, the audience, can help out is you have to help not only your colleagues, your people within just understand what this landscape looks like. So make sure and hit the like button. Share these kinds of videos because it starts to educate people in a way that they're getting much more aware of what's happening around this kind of industry. And I think it does affect kind of the future of where innovation is going to really stem from, because already we've seen so much advancements outside the US. That's the real question mark here. I want to jump over to another topic here with the SEC and what happened with impact theory. This is Tom Bilyeu. I want to go to a clip where Tom kind of explains a little bit about how they cleaned this up. Listen in.
Many people on Twitter have been making the claim that this signifies that most NFT projects can or will be deemed as securities. Do you feel this is an accurate characterization?
Level of aggression from the SEC is high. And so I very much doubt that this is going to be the last one we see. Our announcement is about as encouraging of an announcement as you're going to get for the Web3 industry. So anybody who's, got hecklers in their lives, saying, see, I told you this whole industry is trash and it's full of scam artists, you can just say, SEC did not charge us with fraud. The dissenting statement calls out the fact that we refunded people. The SEC gives an important set of questions to ask for how we move well forward in the future. And I think ultimately this project ought to be used by the community as a way to say, okay, there might be a path forward here, which is hopefully what we all want. We just want clarity. We want to look forward.
Now, with that statement, James, the SEC put a statement out. This is, of course, Commissioner Pierce and also UADA. There's a lot here. I won't go in and read all this, but if you guys want to go check it out, just go to sec.gov and search impact theory. You'll find it. But there's a whole line of questions that Tom Bilyeu was referencing that the SEC was kind of asking themselves that clarity needed to be established for this to occur. Where do you think and what do you think is going to be next steps, especially around Web3 and some of these NFT projects that are starting to flow out into the market?
Well, I agree with the dissent. I don't believe that NFT project was the issuance of a security, and I don't believe it was a close call. I think for the people involved with that project, they were confronted with a math problem. And the math problem was, how much are we going to spend to defend this action and probably prevail in the end when, the SEC is a very powerful force, and it has proven in the Ripple case that it's extremely expensive. And it just points up what an exception to the rule the Ripple people were in having, the determination to fight and not give the bully their lunch money. The SEC wanted this win to break up this line of losses and humiliating losses. They wanted something that they could send a press release out, and they found this project and determined that they were willing to settle. And so they used it. But, people have got to fight and push back, or just like any other bully, they're going to come after more NFT projects. Yeah. And I think the way the law is being understood now in the last couple of years It's just not a close case in most instances that NFTs are not securities, because when you buy an NFT, you're not investing in the issuer. It's not like an equity investment where you have some rights against the issuer, like a shareholder would have rights. And so, it's a math problem, and people settle because they just don't want the distraction and expense of fighting. And again, we really need to credit Ripple, or God knows where we'd be sitting, today.
Well, and I think Coinbase obviously is right there in that fight right now. Obviously, I don't think they have any plans of backing away from this particular situation. So hopefully we'll have another scenario that will play out to the positive side. When you look at this scenario of accredited investors, and I'm just looking at kind of this evolution, and if you look at some of the history here, this is all the way back to 2010 when Obama signed the Dodd-Frank Reform Act, which basically made it an important amendment to the definition, and kind of gave some relevance to what accredited investors needed to qualify to be able to do this. Though it's going to be most common to think of accredited investors as individuals, sometimes this is going to be banks, insurance companies, et cetera. But the key here is you've got 200, and this was all raised. You got 200,000 in joint income, 300,000 in partner income, or a net worth of $1 million. Is there any possibility, as we start to see legislation coming through, especially in digital assets, where maybe this starts to get revisited? Because remember, the SEC was the one that kind of put this in play. Do you feel like accredited investors may ever get revisited here in the future?
Yes. I don't recall now the particular bill. There have been so many. But there's at least one bill, and perhaps more, where they are reconsidering accredited investor for digital assets in particular. And like what percent of someone's net worth they can invest in, and that sort of thing. And it comes across as pretty paternalistic of the government. But when you pull back and get some perspective on it, basically the long march of government is more, regulation and quote unquote protections for small investors, not less. And so loosening the rules would surprise me, particularly in a divided Congress. Right. So it's definitely a space to watch, but over the course of my career, it's more quote unquote protections for smaller investors, not less, not opening up opportunities, because there's a strong contingent in Congress that believes that Bitcoin should be banned and all crypto should be banned, and when companies pick up stakes because of the SEC, cost of battling the SEC and move to the EU or Singapore or Hong Kong or whatever, their reaction is that's good. That's a great thing. And so there's a lot of education. We need younger people who are open to new ideas to come in and replace the old guard over time, for sure.
Hopefully that's going to happen. You've got a couple of key dates here coming in September, September 12th, and then also on the 27th. Gensler's going to get a chance to go in front of the Senate Banking Committee and also the Financial Services Committee. What do you think is going to happen here, James? Do you think he's actually going to get grilled? Is this something where they're going to kind of come to an agreement? What's your theory here on these potential meetings with Congress?
I got to think it's just going to ratchet up, and it's been at a pretty high volume, as you know. You follow all of this so closely, and really do your audience a great service in going into it in detail. And they've been very, very hard on him. So what I'm looking for is there another progressive liberal, beyond Richie Torres that's going to take up the mantle and say, hey, wait a minute. I'm reading these opinions. These judges are saying you're arbitrary and capricious, not just wrong, but arbitrary and capricious is a way to describe how the monarchy acted prior to the adoption of the Magna Carta. They just acted in an arbitrary and capricious manner, and people got tired of it and said, you know what? We need a rule of law to govern how we're going to be treated as citizens in this, in England and all over. And so I would hope that a couple, progressive liberals will join in and really question what's going on here, because the judges, by the way, these opinions are coming down from Obama appointees, and have every liberal credential you can think of as jurists, and they're saying, wait a minute, what this government agency is doing is way out of line. And so now the Republicans who have been on this on Gensler have even more ammunition than they had before. The DC Circuit Court of Appeals twice in a month ruling that the SEC has acted in an arbitrary and capricious manner. It's never happened before. That's never happened. And it's just kind of humiliating. And so they're going to use that, I think, and it'll probably be fun to watch.
Yeah, my theory is that the narrative is going to be on the overreach that you're mentioning there, and maybe that's the positioning. Obviously, Congress is very strong in terms of how they're positioning, especially some of these government agencies. Because hey, listen, this is their job. That essentially the SEC is kind of rug pulling them when it comes to just doing their job. So it makes them kind of look bad in front of their constituents. I shouldn't say kind of. It does make them look bad in front of their constituents. All right, so I want to get a prediction from you, especially around the Coinbase case. Coinbase could get some interesting timing here with also regulation on stable coins. What do you think happens first, regulation or maybe a Coinbase, settlement, win, whatever we might call that?
My guess would be a Coinbase win comes before stablecoin legislation. We really learned something from that Uniswap decision that you started with. The same judge has the Coinbase case, and she granted a motion to dismiss. Remember, this was not a motion for summary judgment like Ripple after 2 years of expensive discovery. This is right at the beginning. She said, you have no case. And so she's very prepared to do that. And it explains, Paul, why she was so prepared in that first meeting of counsel, cross-examining the SEC about, hey, which of these assets are securities and which aren't? And they wouldn't answer. And hey, why did the chairman say there was no, a regulatory framework for exchanges, and they didn't have a good answer for that. She was loaded for bear because she had been working on that Uniswap decision and getting real familiar with the territory. And so I'm quite optimistic that she's going to dismiss that case. And the thing that's kind of hanging out there is staking, which is, new territory and a little more complicated than simply saying, look, blind trading between buyers and sellers on an exchange is not the trading of investment contracts. That's a ground ball. The staking's a little bit more complicated. But anyway, to answer your question, I believe we're going to see a win from Coinbase before we see legislation signed by this president.
Interesting. All right, James. Normally, I would send people to your Twitter account to follow you, but I know some things have been going on over there. Are you coming back to Twitter? What's the plan for MetaLawMan?
Yeah, we've been dealing with a pretty comprehensive cyber attack, and I know others have as well in the crypto space with a profile on Twitter, and so we're dealing with that, and it's far broader for us here than just the Twitter account. But yeah, my intention is to come back to Twitter hopefully soon and be able to share my opinions on all of this interesting legal stuff that's going on.
Yeah. Well, you're definitely missed out there. I know I had a little DM with John Deaton, just, that we need more people like you guys in the space, as many as possible, really. I mean, really kind of defining in this, because it is getting to become such a litigious scenario playing out. You've got to have that experience of understanding, one, how the courts work, then how these agencies have to rebuttal these scenarios, which is a very complicated thing. So we appreciate you guys coming on and doing everything you're doing, James. Appreciate you stopping in today.
Thanks, Paul. I always enjoy being on with you.
You bet. Excellent. All right, so you guys are maybe tuned in on the podcast side of things. Jump over here to the YouTube channel. You can subscribe. And of course, if you hit the little bell, you're going to be able to get notifications of our live streams, all that good stuff for you. Also, you can join our Diamond Circle, which is our way of communicating with you via email. We kind of keep it simple. And we give you additional content. We do another podcast over there. We're getting ready to launch a second podcast in there. And you guys are going to get that if you're a Diamond Circle member. So make sure and just click the link down below if you guys want to get involved. If you want to follow me on Twitter, it is @PaulBaron. We'll catch you next time right here on TechPath.